Welcome to the Spring 2020 virtual conference for the medical malpractice track. Today's presentation is on medical malpractice jury trials. My name is Paul Hart, and I am one of the two co-presenters. I'm also joined today by my appropriately socially distant colleague, Ron Bohm. How are you doing, Ron?
Terrific.
How's your practice surviving COVID?
Oh, very well, actually. Thank you. We're surprisingly busy. My one concern is that the staff who's enjoying working remotely won't want to come back.
I understand that. Yeah, the funny thing is, to be honest with you, I feel I'm just as busy as I was before, although I'm just busy from home. Okay, well, as Ron knows, we actually just finished a jury trial in March. We got very close to the end. We had one witness left when the defense counsel had symptoms which were consistent with COVID, and as a result, the trial was adjourned, and we're probably going to end up just with a judge alone. But nevertheless, having come fresh off that trial, Ron and I both thought there were lessons to be learned, and when we were asked to do this presentation, we thought this would be just an ideal opportunity to talk about that. So Ron and I are going to go over some of the specifics with respect to a medical malpractice trial in front of a jury, and hopefully we can have a couple of tips to share and pass on some useful information.
So to begin with, Paul, why don't you talk to us a little bit about case framing? What does that mean? And why do we do it?
Yeah, sure. So I'm a huge fan of setting up the theory of your case early. One of the general rules, for example, is there's no such thing as a complex medical malpractice case. That's called a losing medical malpractice case. So what you need to do is you need to simplify the case. And there's lots of techniques and ways to do that. And I don't propose to go through them all at the moment, but suffice it to say that, for example, there's the rules of the road, which is an excellent method to establishing rules for a given trial, and there's safety rules. And actually, I was thinking, Ron, can you remember off the top of your head what our rules were on that last trial?
About 2 days after I finished that trial, I probably don't remember any of it anymore. What I can tell you is you need to develop the one that works for you. And that is, think about what is the basic thing that this person did that no one should ever do in their position. That's the rule. What's the basic rule that has been broken? It won't be easy. It may take some work to get to there. Keep in mind that the defense will tell the jury how complicated all this was and how the poor doctors and nurses, whoever it is that whoever the defendants are, really did their best dealing with a very complex situation. Always hear that. So from our standpoint, think about how to make it simple and tell the jury, bull. There's some really basic things they just did wrong.
Yeah, and so, anytime there's some basic principles. For example, if you can't see, don't cut is a rule that I've used. Very short, very succinct. It has to be unassailable, demonstrably true. Those are the kind of the senses, and it's the Patrick Malone, who spoke in our February conference, gave a lot of content on it. And then the other thing you want to be thinking about in terms of your case framing is what vocabulary you're going to use. How are you going to describe certain certain aspects of your case, and then use that vocabulary in a way that hopefully you've thought about and is going to be most effective for your case, and use that vocabulary consistently. One of the things that I've recently come up with is the I just can't get over it. That's another kind of way of approaching it. And that really is an aspect of prioritization of your case and your case theory. And the concept being, what about your case that you just sit down and you go, I just can't get over that? I had a trial, a jury trial actually in January, which settled just on the eve of trial, and it was a suicide case. And the I can't get over it in that case was the hospital had left this young woman who was on a suicide watch with a 6-foot scarf in her room. And that became the I just can't get over that. And that's, the theories and the rules of the roads and the I can't get over it. Once they've set up that framework, that then instructs and feeds everything going forward.
Which segues very nicely into the next thing that we want to talk about. And that really is, once you've landed on what you think is the rule that was broken, the thing that you just can't get over about your case, you've got the theory of your case, you've got your demonstratives ready to go, you've got an outline of your opening and what you think's important. Now, the question is, why would you wait till you're actually in front of the jury to find out if it works? Don't do that. You have everything worked out. Will it work? It's not enough that you think it will. It's not enough that you spoke with family or friends or colleagues. It needs to be focus grouped. So, it's an absolute must. Anybody doing a jury trial without having focus grouped, and maybe a judge alone trial, but certainly a jury trial who hasn't focus grouped it, hasn't done their job. You're not advocating in the way that OTLA has trained you to do it. So you do a focus
I
group.
agree with that 100%, Ron. It really is malpractice at this point. If you're not focus grouping these things, and not only should we focus grouping them, you should be thinking about doing it even more than once.
So, sure, at least once. And here's the thing that if you haven't done it, you just can't appreciate until you have. You will learn things about your case and the way it is perceived that you do not know. It doesn't matter how well you know your case, how well you think that you've got it all figured out. You don't. You don't know how these strangers are going to look at it. You will learn from it, and you will adapt. And by doing that, the theory of your case, the thing you can't get over, the fact of the rule that was broken, the demonstrative evidence that you may or may not use, will all be adjusted. So you'll do it, you'll learn from it. It's a whole separate topic to get into how to do the focus group, but do it.
Yeah, and we've done in fact a seminar standalone on focus groups, and it is just it's just critical. There's never a focus group that I've participated in where we haven't ultimately changed the case. On this last case that we were just doing, we had a client who we had prepped her and spent an enormous amount of time. And in particular, there was an issue with respect to her evidence versus the medical records. And we went in and said, now, whatever you do, don't say the doctors are lying. Say, that's not what I saw, that's my... Don't do that. Well, notwithstanding all this preparation, we put her through a focus group and had her cross-examined. And didn't she say everyone was lying? And what was fascinating to Ron and I was the jury didn't care. They completely, oh yeah, no, she's just saying that, she's confused. But they bought her version of events completely. Now, having said that, we still went back, of course, and told her, no, please don't do that. And she was a little better at trial, at least.
And that's the point to take from what Paul just said, that the focus group isn't just for you. It's equally as important for your client to have been put through an examination in chief in a summary way and a cross-examination, an effective one, in a summary way, in front of a group of strangers, raises her anxiety level, causes her to be much like she will be at trial, and having went through it once, allows her to have the experience of saying, okay, I know what I did wrong. Whew, I don't know why I said this or why I did that, but I know next time I can do better. And so generally they do. So remember, it's not just for you, it's for them too. All right, so aside from focus groups, let's go to our next little topic and talk about trial preparation. So, Paul, big picture. You're getting ready for the trial. You're just getting into a panic. There's a million things to do. Where do you start?
Yeah, well, let me first of all say, do what I say, not what I do. And what I do is I'm always finding that I waited too long to prepare. In an ideal world, you really need to push that back out several months if you can. But the important thing when you're doing this preparation is to set up and accomplish some, a basic checklist. That's the same for every trial. But you also want to have a roadmap, and this is true for both jury and non-jury. The sort of, what do you need to prove? How are you going to prove it? What witness are you going to call it from? The other thing too is, especially for a medical malpractice case, you need to have a chronology. If you do it early and share it with the defense, you're likely to get an agreement on that for the medical terms. An agreed statement of fact, not always possible, but certainly it's going to be very, very helpful. We often use an agreed statement of fact as an anchoring point for witnesses. So if it's an agreed statement of fact, no one's going to argue about leading the witness on some particular point because you're just reading from the agreed statement of fact. The other thing you want to do is have a chronology that, 1-pager, 2-pagers, both for the judge and for the jury, and to set out just the basic fundamental facts. That's very helpful, particularly if you can do it in visual format. People tend to be visual. I often use calendars so they can kind of see, oh, right, so that happened on the Monday and then the next Wednesday, that sort of thing. Very, very important to have all these things done. And when you do them ahead of time, it's going to help you in understanding your case and knowing your facts cold, and it's going to help the jury understand it. Now, one of the things that I haven't really done a lot until this last trial was the use of a jury book. And Ron convinced me of the wisdom of that. So Ron, how do you, why don't you talk about the jury book and how you use it?
So if you prepare a bunch of binders in advance with lettered exhibits A through Z and numbered exhibits 1 through 20, have the tabs all there, have a half a dozen for the jury, one for the other side, one for yourself, one for a witness, one for the court, one for the registrar, so you have lots. What I like to do is to take key exhibits and to make sure that the jury has them, and they have them in their own little book. So you may have 3,425 pages of records, but usually there's about 25 pages that really matter. And so if there's 1 or 2 or 3 key pages on something, you say to the judge, I'd like to give this page to the jury to mark it as Exhibit 1, even if your medical records have already gone in as Exhibit 1. So this would be now perhaps 2 or 10 or whatever it is. That single page from the complete medical records that have been filed on consent. It's very helpful. And then you take your Elmo as you have that one page on the screen, you highlight the important parts, and you can say to the jury, you may want to underline this or make note of that in your book while they're taking notes.
Makes
So
them a
it's
bigger
very
participant in the whole experience, eh?
Very much so. So the other thing is, we ask the judge to make our chronology and our glossary available to the jury in their books. So you're going to refer to the information you gave them to, the nice little calendar, and sometimes that little calendar, that little chronology of what happened when, is the anchor for everything. And you can even introduce that again and again when you're talking to a witness. And say, members of the jury, just for your information, in our chronology, that's item number 5 that we're talking about here.
Okay, so time's limited. Let's move on to picking the jury. And there's lots of our members who haven't done a jury trial, and so why don't you just walk them through that, Ron?
Sure. So to begin with, you can get the jury pool lists from the court in advance. You find out which group of jurors that you're going to be getting to choose from. You can do a little bit of research into those people, Google their addresses. You can find out a little bit about who and what they are, and give some thought to them in advance of the
At least their
actual trial.
socioeconomic status. If you find out where they're living in Rosedale, well, that gives you some indication.
Yeah, and you find out their occupation there as well. So in your focus group, you may have learned some things like, for this type of case, we really found that older men were just all against us. So we'd like to avoid older men on this one. So it helps to go through the jury list. It helps to know, for instance, that we don't want professionals, or we do want professionals, that kind of thing. So just a little bit of homework. Once you're actually there in court, they call somebody up. Of course, you find out very, very limited information about them. You can ask for some information if it is too vague, such as self-employed. It's okay to ask the judge, can we please hear in what field this juror is self-employed in? Judge will usually ask that kind of a question. And then you make your pick. So plaintiff goes first, defense goes next. You have up to 4 times to excuse a juror without reason. Give some serious thought to whether you want to excuse anybody. Because we know so little really about the jurors, be aware that maybe the challenge that you exercise might be getting rid of your best juror, so it's hard to know. But you take your pick, you go with your gut, you have a sense before of who you want and who you don't, and there's a back and forth. And I usually prepare a chart with the 6 jurors on top and 5 boxes deep, so you can know back and forth who the jurors are and note their jury number, and you'll have the names of your jurors so that you can even find out a little more about them during the course of the trial.
Yeah, and on that chart, essentially what happens is if they're challenged for cause, then or challenged, then you just note that down and they get crossed off the list. Very important to kind of keep track of that, just so that by the time you get to the final juror, the jury panel, you've got a decent idea about that.
So let's talk about the opening, Paul. I'd like you to just give a little discussion about that one chance to make a first impression.
Yeah, so again, this is like a really condensed presentation. We could have done it all on the opening, but I just want to say a couple of things. First of all, your opening, less is more. People are not going to remember the detail of a 2-hour opening. So you remember that. And then the other thing is, Ron and I worked on the opening for this trial, and we probably spent 80% of our time on the first 3 minutes. Because in the first 3 minutes, you want to get across to them the key themes of your case, if you can, and also get in those I can't get over it right up front. It's a concept of primacy and recency, so they're going to remember the first thing and the last thing, so you really want to make that count. You want to engage the jury, and you want to be careful, but in the sense that this is not an argument, but that doesn't mean that you can't organize the facts in a very persuasive way. But be careful about, one of the things that I always do before giving my opening, I often write it out. I'm not going to follow it directly, but I'm pretty close to it, because I don't want to get into a situation where there's a redirection from the judge because I've said something argumentative or otherwise. So I always review it, and I sat down with Ron the night before and we looked at, maybe we should just tone this down or just phrase this a little better, a little differently. Often that'll fix the problem, and you can deliver a very, very powerful opening, and ideally you will have won your case on the opening, because really what's going to happen next, you're just going to prove what you set out to do in the opening. Talk to the jury. Don't, we had a situation where we were actually quite far back for one reason or another, and the lectern was facing the judge, and so I just abandoned the lectern and turned. It was a little more difficult to deliver, but nevertheless it's so important to look in the eyes of each and every juror. And I recommend using a PowerPoint. People like visual. I've never seen a trial which can't benefit from a demonstrative. The pictures tell 1,000 words, even if it was a slide with 3 words on it. In fact, that's in this case, Ron, if you remember, we said education, training, and experience. What we were saying was this doctor lacked the education, training, and experience to do this particular procedure. That's all it was, a white slide with 3 words on it. But it was, I think it kept the jury's interest, and it really set up nicely for the rest of the trial.
Absolutely. Remember, we're all visual people now. Anybody who's less than 40 is grown up with learning on computer all the time. So show and tell, big plus in everything that you do. Everything, from the moment you open till the moment you close. It's all show and tell.
Now, one of the nice things about COVID here is I can shut off the camera and I can take a sip of my beer, because apparently you're allowed to do that. Ron, do you want to talk about examination in chief?
Well, they do tell us that the sales of beer have skyrocketed since COVID. So the examination in chief is the sleeper. The examination in chief is the part of your trial that you don't think a lot about, that you say, oh, you just put your client up and get her to give her evidence, and all those people who you're calling, just get them to go through their evidence, read their report, whatever. Examination in chief is critical, it's important, and it's difficult, more so than most people appreciate. So do not let someone drone on and on and on and just tell their story. There has to be interaction. The interaction is what keeps it interesting. Short, sharp, focused questions and focused answers. That doesn't mean you're leading, but that's all about preparation. So the preparation is organize the facts you need to get from that witness, talk about the questions that you're going to be asking, work them through, walk them through their answers, and help them. So that's true of experts, that's true of lay people. Get that script down and make it work. And remember, you need to inoculate, so you always deal with whatever the bad things are that you're going to have to deal with, and you do that in the opening as well. You do that with every witness as well. And then the defense brings it up, and you say, well, yeah, we already heard the explanation for that.
Yeah, I like the title of that slide. You're always sort of, we like to focus on the cross-examination, partly because it's fun, and because I think it gets a lot more play. But in reality, it's the examination in chief, which can really make or break a case, and you really need to spend the time that's necessary to do it. And sometimes too, and we found that in this last trial, we had this the husband, and we kind of ran through what we thought was a reasonable outline, and he didn't get it, and we altered the outline, still didn't get it, and we really needed to structure it in a certain way to enable him to give his best evidence. And I think in the end, he may not have been a star witness, but he was good. He was good enough, mm-hmm. Right? And that's sometimes all you need. Okay, so let's go back to the presentation, if I can do that without.
Yeah. So the next issue to discuss is cross-examination, and that's hard too. So, in a couple of minutes, Paul, how do you do your best to ensure success on a cross-examination, particularly in med-mal where you're dealing with experts from beginning to end? That means the defendants are experts, your experts are experts. Yeah. Everybody has a level of knowledge and expertise that is beyond the lawyer, even the well-trained med-mal lawyer. So how do you plan for success?
Well, again, could be a presentation on its own. I particularly like the Dodner and Posner method, the chapter method, with also some dynamic cross-examination. But the key thing is to set up with a game plan. What do you really hope to accomplish with this particular witness? And set that out in advance, understand how that affects your theory. Oftentimes, you're not going to be able to knock a medical expert out. So maybe you have to come at it just in terms of the underlying, the foundational facts, and nip it sort of at the edge. Don't get into a long, belabored argument with an expert witness that you can't win. And one of my favorites is, and that's why the squirrel is up on the screen, is when you're doing a cross-examination and you think you've got something, stop intellectually, have a pause there and say, do I really want to do this? Am I just chasing a squirrel? Does this really matter to my case? And then the other thing is, I want to say these are simple things, but I see it time and time again. We saw it in this last trial as well, Ron. I would say not from us, but start a cross-examination strong and finish strong, or at least as strong as possible. But don't just kind of wade into it, especially in front of a jury. They're looking for that bang. They're looking for that punch. You've got to have the flourish, and you got to deliver. So start strong, finish strong, and once you've got what you can get done, sit down. The other thing is that we both noticed in the context of this in this trial was the fact that there's always something you can cross-examine on, and some of our witnesses went without any cross-examination whatsoever, and I think that's maybe not wise.
Absolutely not. So cross-examine someone who you have nothing to gain from cross-examining on things that they can't hurt you with, by asking them things that they can't disagree with you with, that have perhaps nothing to do with them, and it just repeats your theme. So think about that. And for instance, I mean, you have a doctor on the stand who has nothing to do with this, but you say, "Doctor, are you aware that nurse so-and-so never did this?" Yeah, I think I saw that in the record. "Oh, and are you aware also that Dr. So-and-so did not do that?" Yes, I think I saw that. "And finally, are you aware that this doctor did not have any experience with the other?" Yes, I believe I was aware of that. "Thank you, doctor." So you've just repeated the theme of your case, perhaps, in questions with somebody who did nothing more but allow you to do that. So cross-examination, look at what they're giving you. It sounds really hard, but it's really not. Read those expert reports. Look for what have they given me. What has he said that went too far? What has he done that is perhaps wrong? What underlying fact did he get not quite right? Those three things, okay, I'm going to start with one. I'm going to find one to put in right at the end of the day or the end of a lunch break or something to end strong, and I'm going to keep my last strong point for the end.
Okay, so let's talk about tactics. Just a couple of quick little pointers that can help some people.
Yes, let's just talk about a couple of ABCs about jury trials. So remember, while you're respectful to the jury should be treated like the judge. So you're not facing the judge while you're asking questions. You face the jury. You're not facing the judge when you're making some submissions. You talk to the jury. When you have the jury come in and you're about to start questioning, a simple thing like, "Good afternoon, Your Honor," and turn and say, "Ladies and gentlemen of the jury." Then you go to the witness. Every time they need to be acknowledged, you need to develop a rapport. They are the people you need to talk to. So many times I see lawyers just, "Thank you, Your Honor," and they start asking questions of the witness, and they never look at the jury themselves. The jury feels left out. If I was sitting on the jury, I'd want people to talk to me. Do that.
Yeah, so let me just tell you, that is a tip that if you walk away with nothing else from this presentation, remember that, and do it with absolute discipline. Every time the jury comes, you're starting with a witness, recognize the jury.
So you're going to marshal the way in which you're going to present your evidence. It's really important. Just think about what Paul said earlier about the opening. Start strong, end strong, primacy, recency. So I want my first witness to be great and maybe untouchable. So perhaps a lay person, someone who has some things to say about how this woman's life has been devastated. Cross-examine her on what? How? How do you do that? You don't. Find out who makes the best impression as a witness. Call that person first. Then think about who makes equally a good impression and call that person next.
Yeah, I remember in our last trial there, Ron, we was such an important thing. We ended up, in fact, not calling the main plaintiff until almost the end of our case because she was just not a good witness.
Bury her, sandwich her in a bunch of good witnesses.
So we sandwiched her in.
Yeah.
She was not horrific, but she was definitely not where we wanted to start our case, which is so good. The other thing I want to talk about is a thing that you kind of convinced me on, and that's, I've always used the ELMO. I think it's so important, or a document presenter. I would just quickly say, you've got these big briefs. Don't either use PowerPoint or use document readers to quickly put those documents up. Don't have everybody flipping through stuff. You want to keep the pace up. But what I loved, which is what you do, and I picked up from you, is the underline. So the highlight. Explain, not that it's that complicated, explain that.
So if there's a particularly important passage in a medical record, you put it up there, and while you're cross-examining a witness on it, you literally take your highlighter and you highlight that section, and it's on the Elmo, and now interactively it's bright yellow. It's almost like warning. It's great.
It was
and
so
the
interactive.
jury sees it, it jumps out at the page, and you can turn your Elmo a little bit to focus in on it, make it big, and suddenly this becomes very important. And you make it important by the way you present it, by the way you repeat it, by the way you highlight it.
Yeah, very interactive. I thought it was very good. So, if Ron was cross-examining or examining a witness, I would do the highlighting, or you could have your junior do it. Very nice. The other point I think we should talk about is the knowing your judge. And so in this particular case, you get a sense of the judge early on, but you got to know, is this judge going to shut down evidence aggressively or not? So sometimes you can make it an absolutely reasonable objection, but the judge just isn't having it, and so you're just wasting your time. And in this case, I have to say that Ron did this spectacular re-examination. It was almost entirely improper, but the judge let him do it, and the other side didn't object, so that was great. But then on the other side, I stood up and objected when they were doing a re-examination improperly, and she had no interest in whatsoever, just wanted to get the evidence in. So you got to understand that, and you've got to be, you got to know your judge and adjust accordingly.
And pay attention. So you may not know much about your judge beforehand, especially if they're relatively new. Do what research you can. Talk to other lawyers who have been before that judge as best you can. It's very important to know. Some judges are very strict about evidentiary rules. Others, come on, just let me hear the evidence. Sit down, shut up, let this person finish their cross or their evidence in chief or even their re-examination. But find out which it is fairly early on. There'll be an objection or two from both sides. You're going to hear the rulings. You're going to get a sense and work with it. So if you have to stay within the stricture of the rules, do it. But if a judge is going to allow you to be a little bit liberal, take advantage.
Okay, so we're still pushing for time, so let's go off to our last topic,
Sure.
which is the closing. And again, it's one of these things which many presentations are dealt with on the close. You want to deliver what you said you were going to in the opening. Again, you want less is oftentimes more. You'll find by the end of a trial you've gone through so much material, but really there's only 10% that's super important, and that's what you want to focus on. And you really should have had your closing done before you started the case, so you should know where the destination is going to be. And again, you want to look at the jury. You want to engage with the jury as best you can. You want to use demonstratives and have an engaging presentation.
Yeah, think about it as your bookends. In the beginning, in your opening, you promise them what you were going to deliver. And in the closing, you get to say, remember in the opening, I promised you A and B and C? I delivered A and B and C.
Yeah, so, hopefully we've given you, in this relatively short presentation, a little bit of a quick overview, or sort of a quick few tips and pointers for a jury trial. The other thing I want to let you know is that both Ron and I are, readily accessible. And if you ever have any questions you want to follow up with by email, feel free to do so, and we'd be happy to assist with any questions you have. The other thing too is that Ron has been spending a good deal of time recently doing focus group preparation, where he'll come in and mediate, or I should say facilitate a mediation during a focus group. It's the first time up, not a bad idea.
And let me just add, you're not going to have that jury trial unless you file your jury notice. So really pay attention and give some thought to the kind of case where you say, this is a very sympathetic case, and it may be technically challenging in some ways, or causation may be difficult, or they may be in a limitation issue. And I think you're better off with a jury where you have technical issues that you were worried about. Juries want to do what's fair and just and will be less worried about technical issues like limitations or causation issues if, in fact, they think it's just and right that your client receives. So think hard at the beginning about filing that jury notice. Judges are often looking at other professionals like doctors as peers. Jurors, not so much.
Yeah, well, thank you very much for your patience with our experiment in this technology. And hopefully you found some of it useful. And I'll tell you, we're really looking forward to getting back into a conference room and the interaction that OTLA is famous for and for which our membership love. So thank you very much.
Thank you all.